On behalf of the DePaul University College of Law's Center for Jewish Law and Judaic Studies, JLJS, welcome to this critical program on defining anti-Semitism and why it matters. Thanks for joining us. My name is Stephen Resnicoff. I serve as a professor at the DePaul University College of Law and as director of JLJS. First, I thank DePaul University and its College of Law for serving as JLJS's home, and I express my gratitude to the College of Law's Dean, Jennifer Rosado, for her continuous encouragement and support. Second, I thank each of today's distinguished speakers, as well as the many prestigious law firms and community organizations that are co-sponsoring today's event. A special hats off to the law firm of Hinshaw and Culbertson LLP for its prodigious technical support, and in particular to Cheryl Winkowski and her team. Of course, I thank all the members of the JLJS Advisory Board for their generous and continuous support. Both of the co-chairs of the Advisory Board, Mark Basowitz and David Levitt, will be speaking today. However much time they invested in that preparation, and it was a lot of time, was at least equaled by their behind-the-scenes work in putting the program together. I also thank numerous people who will be serving as facilitators during the breakout session scheduled for 2:30 Chicago time. A number of these facilitators are themselves eminent scholars of anti-Semitism, whose participation in the program honors us, and whom we hope to convince to serve as featured speakers for us in future events. JLJS is the first and perhaps the only law school program in the Midwest that focuses principally not only on the history of anti-Semitism, but on ways in which legal tools may be used to stem its raging tide. JLJS's work is funded solely by charitable contributions from people like yourselves. You should have received emailed digital materials containing links to a formidable collection of publications pertinent to today's topic. Also included are direct links you can use to make a charitable contribution to JLJS or to the JLJS Scholarship Fund, a fund designed to attract DePaul law students who care about the issues dear to the Jewish community. If you agree with our mission, please support us. Last week, many of us celebrated Passover. In the Haggadah, we read, not only one has risen up to destroy us, but in every single generation, they rise up to destroy us. Many people hoped that the unspeakable horrors of the Holocaust would have a lasting impact, never again. But we know that this is not the case. After witnessing the unbridled growth of anti-Semitism globally, we are experiencing it ever more acutely in the United States of America. We see it not merely in the highly publicized, sporadic, murderous attacks on synagogues, such as in Pittsburgh, Pennsylvania, Poway, California, or Muncie, New York, or on the kosher supermarket in Jersey City, New Jersey. We're seeing a continuous stream of anti-Semitic incidents that is creating a new normal. The New York City Police Department reported that in January 2022, hate crimes against Jews rose by 300% over January 2021. Then it reported that in February 2022, anti-Semitic hate crimes rose by more than 400% over February 2021. These crimes included cowardly, unprovoked physical attacks on the most vulnerable in society, including the elderly and young children. This increase in raw, vicious anti-Semitism is not a regional phenomenon. It's taking place throughout the nation, including in Chicago. It's noteworthy and disturbingly so that in various polls conducted over the past few years by the Conference on Jewish Material Claims Against Germany, more than half of the Americans polled thought that there could be another Holocaust. And more than a third of the French thought that there could be another Holocaust in Europe. Almost a third thought there could be a Holocaust in France, home of a very large, dwindling, but very large Jewish population. This week, an article in an Israeli newspaper stated that almost half of Israelis, 47%, feared that there would be another Holocaust. There have been many webinars discussing the definition of anti-Semitism. So one might ask, how is this conference different from all others? So without slighting any other programs, many of which I viewed and enjoyed, I would emphasize that for the most part, they were relatively short and often directed at primarily non-lawyer audiences. Consequently, they could not devote adequate time, one, to examine or parse the specific language of the various definitions, two, to focus on specific free speech issues from an American rather than a Canadian or European legal perspective. 3, to discuss in detail the practical ways in which the broad adoption of a definition of anti-Semitism could be used to assist in the campaign against Jew hatred. And 4, to provide a guided forum similar to our breakout sessions that will enable relatively small groups of participants to interactively process the ideas and opinions provided in the direct presentations. Although most interaction will take place during the breakout sessions, there may be time for Q&A at the ends of parts 1, 2, and 4 as well. If you have questions during those sessions, please type them in the place designated for Q&A. By the way, I just want to emphasize one of the very important things that we wanted to address is the practical way in which a definition could be actually useful. For example, these are just a few examples. For monitoring, we could use a definition to monitor statutory or regulatory requirements for reporting on anti-Semitic incidents. The Clery Act, a federal statute, for example, that currently exists, requires schools receiving federal funds to monitor hate crimes, including anti-Semitic hate crimes. But the narrow definition of a crime, the narrow definition of a victim of a crime, makes it ineffective to monitor actual hate rather than hate crimes as defined. Second, we could use it in regulating. We could possibly use it in regulating the activities of certain groups of people. Consider, just for example, the American Bar Association's Model Rule 1.8G of professional responsibility. As explained by its official comments, that rule purports to treat as professional misconduct even verbally disparaging conduct based on a number of different grounds. 3, for teaching and investigating and enforcing, we could use the definition to investigate and enforce Titles 6 and 7 of the Civil Rights Act of 1964 regarding the creation of a hostile environment at schools receiving federal funding, or actually the incidents of employment discrimination. And we also could use this definition to help focus private or public opprobrium against those who engage in anti-Semitism. Our first 2 speakers are David Levitt and Carly Gamel. David Levitt is the past president of Congregation B'nai Tikva, a frequent blogger on the centrist Israeli English newspaper or English language e-newspaper, Times of Israel, on issues impacting the pro-Israel and wider Jewish community, and bringing his 42 years of civil litigation and transactional practice to bear on these issues. Mr. Levitt serves as co-chair of the advisory board of JLJS. He has spoken at international conference of Stand With Us on topics such as Israel and international law, as well as on the intersection of the First Amendment and hate speech. And to save time, I'm going to introduce at the same right now, Carly Gamel, the second speaker as well. Carly Gamel is the director of the Stand With Us Center for Combating Anti-Semitism. She also serves the Stand With Us Sadoff Legal Department as counsel for litigation strategy. Carly is a seasoned constitutional litigator with extensive experience handling matters involving free speech and religious liberties and fighting anti-Semitism. Carly's work in combating anti-Semitism derives in part from her background in the educational field, as well as from a deep personal conviction that the world, including people of all races and religions, cannot afford to stand by silently while the Jewish people are targeted, marginalized, demonized, and harmed. With that, David, I turn the podium over to you.
Thank you, Steve. And hello, everyone. It's an honor to be the first speaker, a little nervous to be the first speaker in a program of this nature. And I want to start with a couple of things. First, I'm condensing basically 60 to 90 minute materials into 30 minutes. And that means that I'm assuming that at least some familiarity with the existence of the 3 definitions that we'll be talking about, the JDA, the IHRA definition, and the Nexus document, and we'll be comparing and contrasting them. Second, since I'm not one of the usual speakers that most of the people on this who are attending have heard from, let me just tell you who I am and where I come from. I am not an academic. I've been practicing law, as Steve said, for 42 years, all at the same law firm, commercial litigation, tort litigation, insurance litigation, intellectual property law for the last 20 years. And I consider myself to be a centrist and an independent. So I agree with Republicans on some things, agree with Democrats on some things, disagree with both on many things, and on many of the things I disagree with both sides. And so I'm not coming to this, I don't think, with a preset ideological perspective. And that's important, it seems to me. My wife and I, within our modest means, support candidates, both Republican and Democrat, in the context of pro-Israel advocacy. And I think that's important for people to understand where I'm coming from on this. You should now be seeing my PowerPoint presentation. And I wanted to point out a couple of things because I've written extensively in this area. And that includes my Times of Israel blog. If you want to see what I've written and where I'm coming from, these are examples of the kinds of things that I've written about over time. And I think you'll find that I try and do the research first, investigate it, and come to conclusions that make sense to lawyers and non-lawyers. So here's our agenda for this presentation. First, a description and comparison of the dueling definitions. Second, a comparison of the principles in those definitions to principles that are ordinarily used in law every day. And a third, a proposed paradigm for evaluation of whether conduct or speech is or is not anti-Semitic. I suggest to you that we need to change the tone of the discussion. We need to change the words that are used. We need to create, as Steve said, a new normal, a new normalization of the description of what is or is not anti-Semitic. So what are the three definitions? The first one, and the one of longest standing, is the International Holocaust Remembrance Alliance Working Definition, which was adopted in 2016 by the IHRA. And by the way, the IHRA does not just deal with the definition of anti-Semitism. They have sections on Roma discrimination and they have at least 4 working definitions that are on their website that are easily found. But the one that's currently at issue, the one we're discussing, is the IHRA definition, which was adopted by a plenary vote of 31 member countries in 2016. But as we'll hear, I expect from some of the other presenters, it has a longer history that goes back to the early 2000s. The second one that we'll be discussing is the Jerusalem Declaration on Anti-Semitism, which was first published in March of 2021 and by a group that described themselves. The quote is from their own description of themselves, a group of scholars in the various fields. And the third definition we'll be discussing is the Nexus document, also published in March of 2021, which is a project of the Nexus Task Force, which is affiliated with USC. What's of interest is that the three definitions actually use similar structures. The IHRA definition, and some people call it the Ihra definition, but for whatever reason, I feel more comfortable with IHRA, is a 1-paragraph definition followed by a preamble and 11 non-exhaustive, non-exclusive examples of things that the authors believed counted as anti-Semitism. The JDA is a 1-sentence definition followed by 15 guidelines. And the Nexus document is a 1-paragraph definition followed by 13 examples. What I find of interest, especially as to the JDA and the Nexus document, is that they include examples, unlike the IHRA definition, of what those writers believed were not anti-Semitic. And of interest, all of those examples relate to attacks on Israel or Zionism. That is, that such things are not anti-Semitic, according to the authors of the JDA and the Nexus document. So the next question is, were the JDA and the Nexus document intended as replacements of the IHRA definition? They were both published in the same month, just about a year ago. And why were they published in the first place? Well, the JDA actually says why. It says it because its authors believe that the definition, IHRA definition, is unclear in key respects and widely open to different interpretations, and they sought to improve on the IHRA definition and to have their definition be an alternative to it, to replace the IHRA definition. The Nexus document doesn't have any statements in the Nexus document itself, but on the Nexus website, at least for a time, I believe it's now covered by blocked unless you are a member and you register in, but at a certain time, This was a letter that was sent by the authors of the Nexus document to the Biden campaign during the presidential election, in which they decried a disturbing trend to exploit anti-Semitism in the conservative right and of the weaponizing of anti-Semitism, and that they supported a future Biden administration. So it's clear where those people who were the authors were coming from in their reasons for creating the IHRA definition. And yet, the structure of all three, the definitions, is commonplace in the law. All three definitions utilize the same basic structure. And therefore, when JDA says that the IHRA definition is unclear or widely open to different interpretations, it can't be because of the structure, because the JDA and Nexus document use the same structure. And we do this all the time in the law. For example, the American Law Institute, ALI, puts out what are referred to as restatements of the law. They've been doing this for, I think, over 100 years, and it is common. There's a restatement of the law of torts. There's a restatement of the law of contracts. There's a restatement of the law of conflicts of law. There's a restatement of the law of product liability and of unfair competition, and many others. And the format, and these are cited by courts and lawyers all the time as authority to support their positions on various cases, depending on the nature of the case. And they all use the same format. They have a statement of a legal principle or a series of statements of legal principles, followed by numerous examples and comments. And courts will then, and lawyers and parties will then look at the examples and the comments, as well as the statements themselves, in order to interpret what the law ought to be and how it ought to be applied in a given case under those facts before that particular court. Similarly, the federal rules of civil procedure, and every state has its own rules of civil procedure, which have, for the most part, being in Illinois, we have our own unique set of rules, but most states have adopted their own versions of the federal rules of civil procedure as applied to state court proceedings. And the common practice is a rule with language in it created by the committee, and then they have comments after each rule. And in everyday litigation, parties who are involving with the rules of civil procedure will use the comments to try and interpret the rule and convince the court that it ought to, or the public, given in certain circumstances, that a rule ought to be applied in a certain way and that other analogies might apply. No one claims that these structures render the restatements or the federal rules vague or unclear, such that they should not be followed. So is the IHRA definition unclear or widely open to different interpretations? Part of the complaint about it is that you never can tell ahead of time whether your conduct will later be viewed as anti-Semitic. And yet this is common in the law. We deal with it every day. If you're driving in Chicago on a snowy day in a 35-mile-an-hour zone and the roads are slick and you're going 25 and you have an accident, how fast is too fast for conditions? In product liability, the standard of liability is unreasonably dangerous. And there, in fact, are two different legal formulations for what counts as unreasonably dangerous. How dangerous is unreasonably dangerous? In a negligence case, what would a reasonable person do or not do under similar circumstances is the standard. So what would a reasonable person do or not do? In a copyright case, the area that I practice most often these days, the standard for infringement, or actually for copying, is that the accused work has to be substantially similar to the original work. How similar is substantially similar? I have had many cases where an architect, for example, will come to my office or give me a call and say, I have a customer or a client who's brought in a drawing that they got from another architect or from a development down the street. I'd like you to build something about 3 miles away. Can you do it without infringing on the copyright? And the architect says to me, well, how different do I have to make it? And the answer to all these questions is, it is impossible to say, because you won't know whether it is too fast, whether it is unreasonably dangerous, what a reasonable person would do, whether it's substantially similar, until after the jury decides. All you can do is do the best you can to avoid it, but this is common in the law. We do it every day, and it's nothing different when it comes to the IHRA definition. And we have multi-factor tests that are used every day in every kind of case that you can imagine. I won't go through the copyright fair use in Section 107 of the Copyright Act, but the fact is that the court and the legislature, the Congress, have created 4 non-exclusive, non-exhaustive factors to be considered as to whether or not a use of a work counts as fair use, such that it does not count as infringement, even if it's copying. And that happens all the time. In trademark law, when we're determining likelihood of confusion, there is a test called the Polaroid Factors from the case of the same name. And there are 8 factors that are considered, and they're weighed on a case-by-case basis. Sometimes one of them is stronger, sometimes one of them is weaker. The court has to make a multifactorial analysis to determine whether, in its opinion, under the facts before it, likelihood of confusion exists or doesn't exist. And on top of that, each federal circuit uses a slightly different variation of the Polaroid factor. So some only have 6 factors, some have 9. It varies from jurisdiction to jurisdiction, and yet we still do not claim that likelihood of confusion is vague or unclear, or that we are unable to judge our conduct or the conduct of people who infringe on that basis. In the area of eminent domain, the U.S. Supreme Court applies a 3-factor balancing test to determine whether or not there has been a taking such that eminent domain occurs under the Constitution. In every jurisdiction has the rules regarding change of venue from one court to another, either within the state or from one state to another. And there is a balancing test of both private and public factors, which are balanced and weighed by the court on a case-by-case basis. So the balancing of factors, such as using the guidelines or the examples in any of the definitions, is not what renders it unclear or vague or open to wide interpretation. It can't be, because we do this every day in all sorts of contexts to evaluate the merits of any given claim. There is no reason that a set of examples to be applied in context, and we're going to come back to that phrase, in context, to define anti-Semitism is any different. And in my opinion, then, the assertions to the contrary by those who criticize the IHRA definition are specious and not founded in law or fact. What is the most typical complaint about the IHRA definition? This is a typical one from March of 2022 by the American Association of University Professors, just a month ago. The problem with the IHRA definition is that it equates criticisms of the policies of the state of Israel with anti-Semitism. And the question I ask is this true? Does the IHRA definition do that? And my answer to that question is that it does not. In fact, it expressly says that criticism of Israel cannot be regarded as anti-Semitic, as long as it is the same kind of criticism that's leveled against any other country. And it specifically says, before all of the examples, it specifically says that any given example could, not necessarily is, anti-Semitic, taking into account the overall context. And yet, and I think I've read, well, I can't say I've read them all, but I've read dozens and dozens of criticisms of the IHRA definition. And I can count on one hand the number of them that even mention the existence of the overall context statement. So if we go back to the comments from the Association of University Professors, they don't mention the overall context. If you were to read that entire statement, I just took a blurb from it, obviously, you would find that they don't even mention the overall context provision. They just assume that it limits criticism of Israel or in Zionism, despite the fact that the definition itself, the words of the actual definition, expressly say that they do not limit criticism. So is the JDA, for one, any clearer? All of the guidelines that suggest that things are not anti-Semitic refer to comments or statements that are not in and of themselves anti-Semitic. So to refer to Israel as a settler colonialism state or apartheid state, or to say that using double standards are not in and of themselves anti-Semitic. And the Nexus document does the same thing. Even criticism of Israel for its policies and actions, including those that led to the creation of Israel, is not per se illegitimate or anti-Semitic. Opposition to Zionism and Israel does not necessarily reflect anti-Semitic behavior. Paying disproportionate attention to Israel and treating Israel differently is not prima facie proof. That's the way that each of those alternate definitions frame what they consider to be not anti-Semitic behavior or conduct or comments. So are they clearer? The JDA does not answer. If it's not anti-Semitic in and of itself, when is it? The best the JDA says is that, in short, judgment and sensitivity are needed in applying these guidelines to concrete situations. And I ask the question, because the JDA doesn't mention it in its statements, how is that different? Judgment and sensitivity in concrete situations different than what the IHRA definition says, taking into account the overall context. How is the JDA more coherent, as they say, clearer, less vague? And I suggest that it is exactly the same, or even worse, as we will see. The Nexus document also doesn't ever provide an answer. If it is not per se or necessarily anti-Semitic, when is it? Neither alternate definition gives any guidance on when conduct and speech crosses the line from non-anti-Semitic to anti-Semitic. And as long as we can nitpick and fight about individual provisions of the IHRA definition, we could do the same thing with the JDA. So if, as we just saw, the JDA suggests that it is not necessarily or in and of itself anti-Semitic to refer to Israel as a settler colonialist or apartheid state. So does that mean, using the word settler colonialist, that it's okay to deny the Jewish history for thousands of years in Israel and not be anti-Semitic? Not based on evidence, just based on the claim. What about denying the multicultural nature of Jews in the state of Israel? Are they all settler colonialists? And regarding apartheid, using the word apartheid itself is a loaded term. It's not chosen by accident. The Amnesty International report, which many of you may have read and seen and read stories about, if you haven't read it itself, I've read it itself, and many of you probably have, specifically says that Amnesty International does not seek to argue that or assess whether any system or oppression and domination as perpetrated in Israel is the same or analogous to the system of segregation, oppression, and domination as perpetrated in South Africa. So they've expressly said that they are not referring to the South African apartheid, and yet they demand the same consequences as South African apartheid. The use of the word apartheid is itself a loaded word and demonstrating a slant and a tilt in and an attempt to normalize certain language as applied to Israel. The JDA says that it is anti-Semitic to deny the right of Jews to exist and flourish in Israel, but not anti-Semitic to support equality of all inhabitants between the river and the sea. And my question is, do they really not know what Palestine shall be free from the river to the sea mean? Do they really not know that it means the end of Israel as a Jewish state? What they are really saying is that they are asking that Israel be abolished as a Jewish state, and that Jews ought not to have a right of self-determination in their ancient homeland. There's no question that that's what that language means, in my opinion. Double standards are not anti-Semitic. Forget the question for the moment of whether there's criticism of China and its treatment of the Uyghur population, or whether the Turkish are occupiers of Cyprus. What about just something that's more germane? If we're going to talk about the Israeli treatment of Palestinians as apartheid, what about Lebanese treatment of Palestinians, where Lebanese Palestinians who were born in Lebanon are not allowed to vote, are not allowed to own property, and are not allowed to have certain professions by law? If the same people who are concerned about Palestinians living in the West Bank or in Gaza are not concerned about Palestinians living right next door in Lebanon, I suggest that is a double standard, and it is prima facie anti-Semitic. Singling out Israel regarding treatment of women, which the UN has done on numerous occasions, including very recently, but not countries that allow honor killings and refuse education and prohibit women for being in public without a male family member, I suggest is evidence of anti-Semitism, and that is a double standard. Mentioning Palestinian refugees without acknowledging the Jews, hundreds of thousands of Jews forced out of Arab countries, I suggest is a double standard. And criticizing Israel's military actions, which one can certainly do, but if you don't mention Hamas rockets at the same time and the same level and their war crimes as alleged war crimes, then that is also a double standard. And I suggest that the JDA doesn't deal with that in an appropriate way. And the Nexus document does the same thing. The double standard said, they say that it is not anti-Semitic to treat Israel differently solely because it is a Jewish state, as long as you use the same standards as you apply to other countries. That sounds like the IHRA definition. And yet, it is not anti-Semitic to pay disproportionate attention to Israel and treat it differently. Well, which is it? If it is anti-Semitic to treat Israel differently, but it is not anti-Semitic to treat Israel differently, how does one know when the difference is? And why do we talk about, why is the word solely there? What does that add to the definition? There's more. The Nexus document suggests that it is okay to be pay disproportionate attention to Israel because Israel receives more aid than any other country. It receives $4 billion in American aid every year. But Jordan, Egypt, and Ethiopia each get nearly the same amount, and together Jordan and Egypt, two neighbors, get more than Israel. And yet, why don't we pay attention to the conduct that they have with their residents and Coptic Christians, for example, in Egypt? And UNRWA funding. UNRWA, which has schools that teach hatred of Jews. The US spends far more than any other countries combined. Why is that not okay to raise, to pay attention to that and discuss it? And this one really gets me. It is anti-Semitic to convey intense hostility towards Jews that provokes anti-Semitic violence. Why does it have to be intense? What if it doesn't provoke violence? If you convey intense hostility that doesn't provoke violence, is that okay? Is that anti-Semitic? Is that not anti-Semitic? We don't know because the Nexus document is vague on the subject. So are they improvements on the IHRA? I suggest not. IHRA definition is neither unclear nor vague. It applies commonly used principles of law, which are themselves neither unclear nor vague. And if the IHRA definition is determined to be unclear or vague, then the JDA and Nexus document are at least as bad, and in my opinion, worse. And in my opinion, and I think we'll hear that more about from Carly, the IHRA definition by its own language does not prohibit criticism of Israeli policies or practices, nor chill free speech, and it requires the consideration of context by its own express language. And so I'm suggesting a paradigm to you, a paradigm that we should use in evaluating whether conduct is or is not, or speech is or is not deemed to be anti-Semitic. And again, these rebuttable presumptions occur every day. I have actually tried cases or dealt with cases on all of these that are common in the law. In negligence law, res ipsa loquitur, the defendant's negligence is presumed. The defendant has the burden of proving that it was not negligent. In bailment law, the same thing. Fair Labor Standards Act, if the plaintiff makes out a prima facie case that job action occurred after the employee engaged in a protective activity, it is presumed to be a statutory violation, and the burden of proof shifts to the defendant to show a legitimate justification for its actions, for its job action, firing, changing the person's position, whatever. And just recently in the Trademark Modernization Act of 2020, the legislature, Congress created a rebuttable presumption of irreparable harm such that a preliminary injunction could be issued after the plaintiff establishes a likelihood of confusion. It is common, everyday law. And some words go beyond even having a rebuttable presumption. If someone uses the N word, which after all is a word, it's speech, it is presumed to be racist, and people have job actions taken about them every day. They're not allowed to explain the context. There was just an article the other day, and actually last week, about a judge in Washington who used the N word in the context of giving a talk about hate speech to explain what the word was and why it is hate speech. She had to resign from her position as chief judge as a result. You're not even allowed to use it to explain its history or to criticize its very use. Why should anti-Semitic speech, or conduct be judged any differently. The Nexus document says that opposition to Zionism and Israel may not be anti-Semitic. This is one of their examples, because someone might oppose the principle of nationalism and ethnocentrist ideology. And I kind of agree with that, okay? I mean, if someone is what I would call a John Lennonist, an Imaginist, and the famous song, and they agree, they think their position is that there ought not to be nation states at all, that's a bad thing, okay. But that's part of the context. But if that same person only opposes the principle of nationalism only as to Israel and not as to the US, China, France, Russia, Egypt, take your pick of every nation in the world, in my opinion, that is a double standard. And the context says it is indeed anti-Semitic, and the Nexus document is a straw man, an argument made that has no merit. You're knocking something down before it even existed. And I've debated this. One could say that the existence or the borders of the state of Israel is a result of the arrogance of European nations after World War I and dividing up the former Ottoman Empire. And that may not be anti-Semitic in context. It may not be. But if you single out only Israel and you don't include a discussion of Lebanon and Syria and other countries that were created at the same time by the same League of Nations mandates, by the same arrogant European nations, then you're applying a double standard. And I suggest it is indeed, and Jordan, by the way, it is indeed anti-Semitic. So I suggest the paradigm. The IHRA definition examples do create rebuttable presumptions of anti-Semitism. They can be rebutted, but the burden is on the speaker or actor who says or does something within the scope of one of the definitions and the definition and its examples, not on the person who suggests that the conduct or speech is anti-Semitic. And this is consistent with most of the occasions when anti-Semitic speech or conduct actually occurs. While context is always considered, the vast majority of the facts within the examples are anti-Semitic, and the ones that aren't are the exceptions to the rule, not the rule. And this is consistent with commonly understood and applied principles in many areas of law that courts, lawyers, and their clients use every day. In conclusion, the alternatives to the IHRA definition are neither clear nor improvements. Critics of the IHRA definition employ straw man arguments that are at odds with most occasions of potentially anti-Semitic conduct or speech. The IHRA definition allows robust debate about Zionism and Israel without being anti-Semitic, but draws reasonably understandable lines for when the debate crosses those lines over into anti-Semitism. In my view, the JDA and Nexus documents were designed and published in March of 2021 specifically to give cover so that people who would otherwise be accused of anti-Semitic comments can use that as a defense and claim they were not anti-Semitic. Thank you.
Thank you very much, David. Now we're going to hear from Carly. Take it away.
Thank you so much, David. That was fantastic. Let me get this here. Okay. Well, we're going to delve a little more deeply into some of the issues that David raised, but I do want to give the disclaimer that this session is not intended to be any sort of an exhaustive primer on the First Amendment, including the free speech clause, but it is intended to discuss the extent to which the IHRA working definition of anti-Semitism implicates the free speech clause. So with that, I believe that the best way to start is with the text. So let's look at the text of the First Amendment to the United States Constitution. And again, focusing on the free speech clause, which I've bolded here. And essentially it says this: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or, and this is our focal point, abridging the freedom of speech or of the press. And then goes on to discuss right to assemble and petition the government for redress of grievances. So what does this mean? I know we have a number of attorneys who are attending, but I know we also have a number of lay people who maybe don't know what the general rule of application of the free speech clause is. And it's simply this, that the free speech clause prohibits the government. It does say Congress, yes, but that generally has been understood for a number of years based on Supreme Court precedent to include not only Congress specifically, but the federal government as well as state and local government entities. So the free speech clause prohibits the government, as opposed to private citizens or groups, from penalizing or restricting speech based on the content of that speech, right? Essentially, the government doesn't get to tell private citizens what they can or cannot say. That's the general rule. There are obviously a limited number of exceptions, some areas of speech that have previously been referred to as having low value, things like defamation, true threats, fighting words, incitement, things like this. But other than those limited exceptions, most other content-based restrictions or penalties imposed by the government are presumed to be unconstitutional. And that includes speech that is offensive or hateful, including, for example, anti-Semitic speech. So again, general rule is that even anti-Semitic speech is protected against government infringement by the First Amendment, by the Free Speech Clause. Also, this will become important a little bit later. The free speech clause doesn't apply to government speech, right? So we've said that it applies in such a way that it prohibits the government from infringing upon private speech, but the government is understood to have its own right to speak, and the free speech clause generally cannot be used to challenge speech that's attributed to the government itself. For example, to claim that because the government has taken a particular position on an issue, that it is somehow engaged in viewpoint discrimination. Again, when the government itself is speaking, that rule does not apply. Okay, let's now look at the text of the IHRA working definition of anti-Semitism. Again, as David mentioned several times, text is crucial. And if we're going to understand this, and if we're going to understand the implications of it, we have to first begin with the text. So again, what's here in bold is the actual definition, the IHRA working definition of anti-Semitism. And it's simply this: anti-Semitism is a certain perception of Jews, which may be expressed as hatred toward Jews. Rhetorical and physical manifestations of anti-Semitism are directed toward Jewish or non-Jewish individuals and or their property, toward Jewish community institutions and religious facilities. That's the definition proper. Then the IHRA has gone on to provide some further guidance and explanatory information. And that's what you see in this next paragraph. Beginning in this next paragraph, it says manifestations, again, of anti-Semitism might include the targeting of the state of Israel, conceived as a Jewish collectivity. However, criticism of Israel, similar to that leveled against any other country, cannot be regarded as anti-Semitic. Anti-Semitism frequently charges Jews with conspiring to harm humanity, and it is often used to blame Jews for, quote, why things go wrong. It is expressed in speech, writing, visual forms, and action, and employs sinister stereotypes and negative character traits. And then right after this guiding language, again, David alluded to this a moment ago, the IHRA goes on to provide that contemporary examples of anti-Semitism in public life, the media, schools, the workplace, and in the religious sphere could, taking into account the overall context, include, but are not limited to. So again, a non-exhaustive list of 11 contemporary examples of what anti-Semitism may look like. And some of those things include calling for, aiding, or justifying the killing or harming of Jews in the name of a radical ideology or an extremist view of religion. And again, remember that as these examples are being understood, it's not a per se rule, right? The introduction to this section says that these are things that could be anti-Semitic, again, taking into account overall context. So that's one. Making dehumanizing, demonizing, or stereotypical allegations about Jews or the power of Jews as collective, such as the myth about Jews controlling the media, economy, government, etc. Accusing Jews as a people of being responsible for real or imagined wrongdoing committed by a single Jewish person or group, or even for acts committed by non-Jews. Denying the fact, scope, mechanisms, or intentionality of the genocide of the Jewish people at the hands of National Socialist Germany and its supporters and accomplices during World War II, the Holocaust. Accusing the Jews as a people, or Israel as a state, of inventing or exaggerating the Holocaust. And then a few more. Another example could be denying the Jewish people their right to self-determination, for example, by claiming that the existence of a state of Israel is a racist endeavor. Applying double standards by requiring of Israel a behavior not expected or demanded of any other democratic nation. Using the symbols and images associated with classic anti-Semitism, for example, claims of Jews killing Jesus or blood libel, to characterize Israel or Israelis. Drawing comparisons of contemporary Israeli policy to that of the Nazis. Holding Jews collectively responsible for actions of the state of Israel. And finally, accusing Jewish citizens of being more loyal to Israel or to the alleged priorities of Jews worldwide than to the interests of their own nations. All right, so here you've now seen the entire text of the IHRA working definition of anti-Semitism, its explanatory guidance, and the contemporary examples of anti-Semitism. It should be clear, based on all of this, that what this definition is a tool. There is no rule of prescription or proscription, right? This definition, the examples included, none of this text says what anyone may or may not say, right? There's simply no enforcement mechanism whatsoever. There's no rule laid out in here. The IHRA definition of anti-Semitism provides information about anti-Semitism and about various ways in which it may manifest. And that's important because the purpose of the IHRA definition is similar to that of any other definition. It is to provide information and to help in identification of anti-Semitism, right? So the primary purposes of this definition are to help identify anti-Semitism, to increase awareness about anti-Semitism, to provide some consistency in understanding and addressing anti-Semitism, and to encourage and increase the reporting of anti-Semitism. But there again, not a single line in either the definition proper or in any of the explanatory guidance indicates a rule of any kind. Again, I think that's pretty clear, and so I don't want to overly belabor the point, but it cannot be overstated. I think that that's what this text provides. All right, so with that all in mind, let's take a look then at some of the free speech principles, concepts that may be implicated by the IHRA definition of anti-Semitism. And when I say maybe, I mean that primarily in the sense that there are claims by those who oppose, for various reasons, the use of the IHRA definition, that there are free speech principles that are implicated, and in fact, as the claims go, that in fact these principles are violated by the IHRA definition of anti-Semitism. So the first of those is that somehow the definition criminalizes speech. This claim is easily addressed simply by looking to the text that we've just looked at. As we've seen, there's not an iota of any text in that definition that would indicate criminalization of any kind. No rule whatsoever, let alone a rule threatening punishment for any speech that might be identified by the definition as anti-Semitic. In fact, following the contemporary examples, the IHRA went so far as to clearly state that anti-Semitic acts are criminal when they are so defined by law. So that line in and of itself makes it very clear that the rest of the text of the IHRA definition has absolutely nothing to do with criminality. So again, I think looking at the text of the IHRA definition, it becomes abundantly clear that there is simply nothing in that definition that could reasonably be understood to criminalize any speech. Next, though, the argument goes that even if it's not a criminal penalty, that the definition itself silences or has a chilling effect on protected speech. Again, as with the criminalization argument, I think the text of the IHRA definition easily answers the claim that it somehow silences certain speech. And again, that argument, as David alluded to, is most commonly raised in reference to speech about Israel that is identified within the contemporary examples as potentially anti-Semitic. And so the argument goes that criticism of Israel in various ways is silenced somehow by the IHRA definition. And again, those are the things that we looked at a moment ago, things like denying the Jewish people their right to self-determination, or applying double standards to Israel and its behavior, or drawing comparisons of contemporary Israeli policy to policies of the Nazis. Those types of things, so the claim goes, are silenced by the IHRA definition. Again, looking back to the text, there's simply no basis for that claim, because these things are merely identified as potentially, and again, that's important, depending upon the overall context, potentially anti-Semitic, merely identified. There is simply nothing in the definition itself that indicates that anyone is in any way prohibited from engaging in that type of speech, merely identifies it as potentially anti-Semitic. The slightly more nuanced version of this argument is that by identifying such rhetoric and speech as potentially anti-Semitic, the IHRA definition, quote, chills protected speech. And that is simply the claim that it deters the exercise of speech rights that are protected by the First Amendment by appearing to target expression. In other words, if the definition indicates that certain speech about Israel may be anti-Semitic, even if it's protected speech, even if it's entirely permissible for an individual to engage in that speech, that they may refrain from doing so because the definition includes it as potentially anti-Semitic. The first thing that I think has to be understood about this is once again, the definition itself includes absolutely no rule, no enforcement mechanism or suggestion of any kind. And so it's a far cry from chilling speech, which generally means that there's a law in place that appears to target expression, and it causes people to think twice before they engage in that certain expression because it may be covered by the restrictions or penalties in that law. Again, in the absence of any penalty or restriction, as in the Ihra definition, it's difficult to see how merely identifying subject matter or content as potentially anti-Semitic would cause someone to refrain from engaging in that speech for fear of a penalty, again, when there is no such thing. And I would submit that in fact, any second guessing that might go on in that particular context, that's simply part of being engaged in civil society and thinking twice before you say something that might be bigoted. I see that as a positive rather than a negative. And so again, that's essentially the argument with regard to chilling effect that claimants make with regard to the IHRA definition of anti-Semitism. And I think it's important to understand a little bit of the background of this concept of a chilling effect on speech, because there are some related concepts in First Amendment law. And again, this is delving maybe a little deeper than some would normally go, but I think it's worth understanding the background and helpful for those who do want to do a little bit more research and understand a little bit deeper where this all comes from. So one of the concepts in free speech jurisprudence that is related to the chilling effect is the idea of vagueness. And again, David touched on some of this, the notion that somehow the IHRA definition is not sufficiently clear. And in addition to the concepts that David explained as to why the definition itself is not vague in a problematic way, I think it's also important to understand that what vagueness means in the constitutional sense in terms of the law. And essentially what it means is a law is considered unconstitutionally vague when people, quote, of common intelligence must necessarily guess at its meaning. Again, as I mentioned a moment ago, that what that means is, I read a law that says, that either I can't say or do something, or that there may be some penalty imposed if I say or do something, but it's not clear enough as written for me to be able to determine what speech or conduct is actually covered. And so again, that's the idea of vagueness within the law. And of course, it's a heightened concern in the First Amendment context because of the fear, like we said, that such laws might chill a person in the exercise of their right to engage in protected speech. I'll refer back to David's session as to some of the explanation as to why the definition itself and its examples are not vague, that they are sufficiently clear for anyone to understand what it is the IHRA has determined is potentially anti-Semitic in terms of these examples. And again, but I also want to go back and always underscore the fact that there cannot be a concern with the definition in and of itself, again, because it's not a rule. It's merely a tool for identifying. And so there again, the definition itself does not run afoul of any constitutional rule regarding vagueness. A related principle to vagueness here is the overbreadth doctrine. And that just simply says that a law is unconstitutionally overbroad if it sweeps so broadly that it regulates not only unprotected speech, but also a substantial amount of protected expression. Again, when you look at the text of the IHRA definition, again, we're being reminded that there's simply no rule enforced by it. It's a tool for identification, and it doesn't sweep broadly at all. It provides what is a non-exhaustive list, but in providing those examples is very clear in terms of the types of rhetoric that may in fact be anti-Semitic when the entire context of a given situation is taken into account. So again, I don't see any concerns legitimately, first of all, in the definition itself, but then we'll talk in a minute about the use of the definition. I don't see any concerns in terms of the text being overly broad in the constitutional sense. Then lastly, with regard to chilling effect, the idea of unbridled discretion is a concept in First Amendment jurisprudence that's related to vagueness and overbreadth. And so again, kind of informs the argument about the IHRA definition having a chilling effect. And it's really just the principle that laws regulating speech are required to provide sufficiently explicit standards for those who are charged with enforcing them. Again, otherwise that leaves authorities with, quote, unbridled discretion to inquire into, for example, the message, the content of speech, and to make unconstitutional content-based decisions in terms of who may and may not speak, when, where, the like. So this is a related concept that, again, could come into play if we were talking about a law, a rule that was set down by the government that dealt with what one may or may not say. Again, we're not dealing with any such law or rule when we're talking about the IHRA definition of anti-Semitism. So again, for all those reasons, with an understanding of kind of the background of the arguments that are made with regard to the definition and free speech, it's abundantly clear from the text of the definition that it does not run afoul of any of these principles. It's neither a law nor a rule, includes absolutely no indication of what anyone may or may not say. instead provides information that may help to identify speech or conduct that is anti-Semitic. But what about incorporation of the IHRA definition within various legal provisions? We see this all the time. David mentioned a number of common practices and principles in the law that are relevant when talking about the IHRA definition. I think it's important to note that in many cases, including beginning with the United States Code of Federal Laws, the very first section of many laws is a definition section, right? So there's nothing inherently problematic, legally speaking, with including definitions in a law, incorporating them. In fact, in most cases, it is necessary to avoid some of these concerns when it comes to vagueness or overbreadth or unbridled discretion. We have to define the terms that are being used in laws that affect individuals' rights. And so what happens when a government entity decides that it's going to legislate with regard to anti-Semitism? Let's say, for example, it could be a hate crimes law. It could be just a general non-discrimination law. And that government entity decides that the definition that it will use in enforcing that law when it comes to anti-Semitism is the IHRA definition. So I want to look at an example. We're going to skip past this for just a second, this government speech, which we're going to come back to. And I want to look at an example, and you have it in the packet of materials that you were provided. And this is section 2 of an executive order from December 11th, 2019. It's executive order 13899. And I've excerpted here section 2 of that executive order, which is entitled Ensuring Robust Enforcement of Title VI. And here's what it says. And to be clear, what we're talking about is Title VI of the Civil Rights Act of 1964, which says that recipients of federal funding may not discriminate on the basis of race, color, and national origin. So what this executive order provides is, in Part A, is that in enforcing Title VI and identifying evidence of discrimination based on race, color, or national origin, all executive departments and agencies charged with enforcing Title VI shall consider the following: the non-legally binding working definition of anti-Semitism adopted on May 26, 2016 by the International Holocaust Remembrance Alliance, which states, and then it provides the text of the definition proper. So in enforcing Title VI, right, in identifying evidence of discrimination for the purpose of enforcing Title VI, this is the definition that executive agencies are now required to consider, as well as the contemporary examples of anti-Semitism identified by the IHRA, which again, we've looked at that list of 11, to the extent that any examples might be useful as evidence of discriminatory intent. If we look at the text, we've already looked at the text of the IHRA definition, and we've now seen that it merely provides information about anti-Semitism and a tool for identifying things that may be anti-Semitic. And now we have a government entity, the executive branch of the federal government, saying that in terms of investigating potential anti-Semitism for purposes of enforcing Title VI of the Civil Rights Act of 1964, this is the definition of anti-Semitism that is to be used. There's simply nothing in that rule that changes any of what we have said about the definition itself. If that's the definition that's to be used, and then we go back to the text of the definition and we see the definition proper, which is here on the face, as well as the examples, which again are introduced by the statement that these could be anti-Semitic, taking into account the overall context, then none of the concerns about chilling or silencing speech, vagueness, overbreadth, unbridled discretion, none of those concerns, in my view, are brought to bear here. They're simply not implicated because of the fact that we're simply saying this is the definition that is to be used. We're not changing any of the rules, any of the laws with regard to what is or is not considered discrimination that might violate Title VI of the Civil Rights Act. So this is an example of a way in which the IHRA definition is utilized in terms of legal provisions. And then I want to be really clear and highlight here in Section 2, Paragraph B, that just to make sure that it's abundantly clear that there is no misunderstanding, this executive order also states that in considering the materials described in the previous section, agencies shall not diminish or infringe upon any right protected under federal law or under the First Amendment. In my experience, having looked at a number of legal provisions that do incorporate the IHRA working definition of anti-Semitism as the definition to be used in enforcing said laws, a provision to this effect has been included across the board. And again, it's simply because there is an understanding that there may be arguments raised about the use, the implementation, and the application of this definition, and that in no way is the use of this definition, which identifies certain content as potentially anti-Semitic, in no way does that mean that in so identifying that speech as anti-Semitic, that free speech rights can be diminished in any way. So in the same ways that we saw at the very beginning that the free speech clause of the First Amendment generally protects even offensive hate speech like anti-Semitism, that continues in full force even with the use of the IHRA definition within a legal provision as the definition of anti-Semitism. So I want to leave you with this thought as well, and you'll see that you have in your packet some additional examples, at least one other example of a state law that uses the IHRA definition, and I think if you study that, you'll see that the same things are true with regard to that law as what we've just seen here. I want to go back though, and I want to mention the government speech doctrine for this reason. I mentioned earlier that the First Amendment free speech clause can't be used to challenge speech that is attributable to the government. And that's really important. And again, you have something in your packet that I think is really helpful in driving this point home. Again, the understanding that the government itself has the right to speak, to use its own voice, and can take positions on given subjects. And here's why this is important. In a recent amicus curiae brief that was filed at the United States Supreme Court, the AJC astutely argued that adoption and use of the IHRA definition by government entities to identify, and if they so choose, to condemn anti-Semitism, including anti-Semitic speech, is in itself an important act of government speech that should be immune from First Amendment challenge. And here's what they say, and again, I think this is important to understand why, how the First Amendment is implicated versus basically what we've been saying so far is that it's really not implicated in terms of private speech, but when it comes to government speech, it very much is. And this is what the brief says. Government adoption of the working definition is more than a symbolic step. Practical applications, including training of government officials and employees, identification and categorization of anti-Semitic incidents, and support for decision-making processes. Because the working definition is generally not legally binding, its use depends on adoption, public endorsement, public acceptance, and documentation in publicly available sources. In short, on vigorous and continuous government speech. And then it goes on. Such public discourse, giving attention to the meaning of anti-Semitism and calling out anti-Semitic words and actions, is highly valuable government expression in response to a pressing need. More than 1 in 3 American Jews, 37%, have reported being victims of anti-Semitism over the past 5 years. And that percentage rises to more than 4 out of 10, 41%, younger American Jews between the ages of 18 and 49. Yet nearly half of Americans profess unfamiliarity with the term anti-Semitism or its meaning. Government voices recognizing what anti-Semitism is and calling it out when it is observed thus serve a powerful educational and moral role in response to a rising threat of intolerance, bigotry, and hate. It is more speech in response to falsehood and fallacies. I'll leave it to you to read the entirety of the brief. I think that the arguments are well made, and I'm appreciative of the fact that AJC filed it and has now given us that food for thought. And with that, I will turn it back over to the powers that be.
Thanks, Carly. I suppose that means me, but I'm not certain. But I'm going to take the power. We just have a couple of minutes for a couple questions, and I mentioned most of the discussion will be in the breakout sessions after we've heard all of the presentations. I'm going to ask a couple of questions that came through to me, and I'm going to. I'm not good. I don't. It's not that I have the question. It's not that I don't think you've already addressed the question, but this is the question as I understood it as put by the audience. The first question is for David. David, the question is presumably under the Ihra definition, although the question didn't mention which definition, is it anti-Semitic to advocate a one-state solution?
I'm coming back. So the short answer is no, in my opinion, depending on how you do it. I mean, if you advocate a one-state solution in which Jews do not have a state, and we abrogate the Jewish state, then I would say it is, because you're denying the Jewish right to self-determination in their homeland. On the other hand, if it's a one-state, but generally, just because you advocate a one-state solution doesn't mean that you are anti-Semitic. There may be reasons that are not anti-Semitic.
Okay. One more question for David. David, actually for either of you or both of you, the Ihra definition, each of you referred to a provision that talked about applying double standards by requiring of Israel a behavior not expected or demanded of any other democratic nation. And the questioner said, well, many of the examples that were mentioned were not of democratic nations. And do you have examples of where double standard is applied to Israel as opposed to applying it to other democratic nations?
Well, Lebanon may be a failed state in some respects, but it is a democratic nation. Its leaders are elected, Hezbollah notwithstanding. Although Hezbollah is elected too into the government. The law was passed by the legislature. Jordan has a monarchy, but Jordan has an elected legislature. Egypt has an elected legislature. I mean, I know they had a coup and all that, so there's all sorts of issues there. But if you're applying double standards in terms of for example, that or if you don't believe in nation states generally, which is one of the if I recall correctly, the Nexus examples of why you might apply disproportionate attention to Israel rather than other countries, because you don't believe in nation states, but you don't say that about the United States or England or France, democratic states all, then that's a double standard. Obviously, there are some other things that are more unique to democratic states than others, but in general, the rules are the same, no matter which kind of country it is.
Thank you, David. Carly, did you have anything you wanted to say on that point?
I think I would just add that I think that example specifically really highlights the important distinction between legitimate criticism of Israeli policies, government actions, because they are a democracy. And there are certain expectations that individuals have, and perhaps rightly so, of a democratic nation. But the question then becomes, are we holding Israel to that standard while David used the example earlier of military criticism of Israel and yet the absence of commentary at all about Hamas rockets And so to make the claim that, for example, a one-sided claim, right, that the Israeli military is somehow responsible for certain violence, but to ignore the impetus for that, to completely ignore, for example, that perhaps that was triggered by Hamas rockets. I think any democracy, regardless of the expectations that one may have of it, that ought to include the expectation that it's going to defend itself and its citizens against terrorism. And so again, I think that that's a perfect example of kind of understanding the distinction between what is a double standard and what might be legitimate criticism.
Thank you both very much. I myself have many questions, and I'm sure other people do as well, but we have to move on to part two